Hello, good day, and welcome to today's webinar, Managing the Aftermath of Hanjin, presented by Rick Bridges of Roanoke Trade and Richard Furman of Carroll, McNulty & Cull. My name is Matt Zahner, Vice President, Surety Information and Analysis at Roanoke Insurance Group, and I'll be your moderator. Today's presentation is scheduled to run for 50 minutes with an additional 10 minutes for questions and answers. Please note that all attendees will receive a link to a recording of this webinar and the accompanying slides in an email within a few days. Before we get started, I'd like to tell you how you can interact with us today. All webinar attendees will be in listen-only mode. Throughout the webinar, we encourage you to type your questions into the question box in the control panel at the right of your screen. We'll answer as many questions as time allows during and at the end of the presentation. About our presenters. Rick Bridges, Vice President of Roanoke Trade, has been with the company since 1998. He resides in Massachusetts, and his scope of responsibilities includes service and sales within the New England region. With over 18 years of international trade and insurance experience, Rick is a well-respected advisor on insurance and risk management matters involving the trade and transportation of freight. In addition to his experience in transportation, insurance, and bonds, he is a skilled multi-line commercial insurance agent licensed in several states. Richard Furman has been a member of the Carroll, McNulty & Cull law firm since 2008 and serves clients in the freight forwarding and custom brokerage industries. Today, CMK clients benefit from his extensive experience representing companies that are engaged in international and domestic transportation and trade. He currently serves as the United States General Counsel to a number of global transportation service providers. In addition, Richard is engaged by subrogated insurance companies to defend claims against transportation service providers for loss, damage, or delay to goods in transit, as well as liability for errors or omissions in the handling of shipping transactions. Rick, would you like to begin?
Sure. I'm going to turn this over to Richard again.
Oh, that's it. I'm up?
You are.
Okay. The thought is that while everybody who's attending or participating in this probably has some understanding as to what's been transpiring and has probably tried to keep track of what what's been going on, the best way to start is to probably make sure everyone's on the same page by sort of bring us all up to date as far as what's happening, and some of the issues that have yet to be resolved or are still up in the air. So while the real goal is to get to the kinds of practical advice that hopefully will benefit the participants, let's just review where things started and where we're at. The filing by Hanjin on August 31st of an insolvency proceeding in Korea was really intended for what was known under that law as a rehabilitation. That's roughly equivalent to the Chapter 11 reorganization statutes that we have here in the States. The problem you have with a company like Hanjin is that it has far-flung interests and assets. There were at that time, and typical of such companies, goods, products, equipment, assets distributed all over the world. The court in Korea has jurisdiction over these things, but doesn't have necessarily the practical ability to supervise them in such far-flung jurisdictions. There's a treaty that exists among many of the trading nations of the world, which basically enables the courts, the bankruptcy courts in the various countries where assets of a bankrupt exist, to exercise a degree of control over those assets, primarily in cooperation with the court in the home country where the bankruptcy was filed. It's in the U.S. it's under Chapter 15 of our bankruptcy code, and it's a relatively new statute, and it has not been used that much, and it's used very conservatively in terms of how the courts exercise any involvement in the bankruptcy. The U.S. court here has shown, and it's typical of these things, a great deal of deference to the management of the bankruptcy in Korea. It doesn't want to get ahead of itself. It doesn't want to make decisions or get involved in issues that more properly can be addressed in Korea. And then to the extent they need to help implement those things, that's where the court will get involved. So at present, that Chapter 15 petition is still pending final approval, and that was filed on September 2nd. But there have been a number of interim hearings since it was filed, in which a number of issues were raised by various interests that are being affected by this, not only, of course, Hanjin, but terminal operators, vendors who have claims against Hanjin, beneficial cargo owners, NVOs, and anyone else who's being impacted by all this. And the court's been trying very carefully to address them, but for the most part, all it's really done so far is to impose the typical kind of stay that you would find in a domestic bankruptcy, basically saying, hands off, all Hanjin and all its assets are under the protection of the court. You can't take any action against them, and beyond that, it hasn't really been too proactive. There have been at least one seizure in the United States of a Hanjin vessel before the bankruptcy, the petition under Chapter 15 was filed, and that's up in the air. The court has yet to rule on how that's going to be addressed in the final order, but for the time being, no action can be taken in furtherance of that arrest. Some of the issues that have come up in the course of oh, Rick, I'm sorry, why don't you flip a couple of the slides here? I forgot you had the key. Okay. There have been a number of issues that came up in these interim hearings. You can see from the slide that there was a hearing on September 2nd, another one on September 7th, and it was at that one that the provisional order granting the recognition of the Korean proceeding was issued. And then again on the 9th, there was at that time some effort made by beneficial cargo owners and others regarding what they could do about getting the goods off the vessels and off the piers at that point, and the court was not proactive in that. It basically said, you guys take care of it. I don't think I have the jurisdiction or at least the authority to go that far at this stage. Some understanding was discussed, but Hanjin basically rejected it as untenable or unacceptable. There was also an application by some bunker and charter party interests for leave to be able to arrest Hanjin vessels to secure their claims for sums that would due them. That was denied. Rick? And the court went on to issue the provisional relief, or that is not final yet. It's still pending, but the order is still in effect. It freezes everything. As I said, it stays any actions that anybody might want to take to try and obtain satisfaction of their claims. It's been the court's basic policy throughout this to put everything back on the parties. If anybody has taken the trouble to look at that provisional order, there's a protocol or exhibit attached to it, and it spells out the fact that the beneficial cargo interests or their agents or others who have, are in a position to wanting to get cargo off the piers or off the vessels have that right, and provides other, other guidelines as to how that could be done. But he's not and will not at this point, issue an order saying this is what you have to do. This is, he won't tell can't tell Hanjin, you have to unload the vessels. He can't tell the terminals you have to receive the freight, or the ILA you have to, you have to handle the freight. It's all been done pretty much on an, ad hoc basis. For example, at one point the ILA was refusing to handle the goods, even the ones that were already on the pier and had yet to be either loaded or had been discharged and yet to be delivered. And that was on a Friday, and they basically shut down the East Coast because of it. And then over the weekend, everybody got together and they agreed on a per container fee that the ILA would get paid, and by Monday they were back in business. But it was up to the parties to work that out. There was a third hearing on the 15th, and that was where the ILA first raised the issue about the not wanting to handle the containers. But at the same time, there was an NVO group submitted a motion to the court asking that it be subject to the same treatment under that Exhibit A, that protocol to the preliminary order. In particular, they wanted to make sure that they were considered beneficial cargo owners in the same way that an actual receiver would be. And they also wanted some information about the rates that Hanjin was paying the terminals and others for the handling of the goods, because as some of you may know or may have heard, there has been, as some merchandise has been released and gone into delivery, some gouging by some terminals in terms of the handling fees that they were demanding to release the containers, some gouging by those carriers, inland carriers, that were willing to even accept transport of the goods over and above what they would have otherwise been charged. So that the NVO group wanted to know, what would be fair, what's the fair and reasonable amount that Hanjin would have otherwise paid if if they had gone ahead and been able to complete these moves, and the court denied that, interestingly enough. So and as a practical matter, the reality is, if you sat there, if you go to the terminal, you go to a carrier and you say, I want my goods, I have an opportunity to pick them up. What are you going to charge me? And they charge some ridiculous amount, and you say, well, wait a minute, that's not what you would otherwise have charged Hanjin. They're going to say, well, that's what we want. Well, if you start demanding to find out what those charges are, excuse me, the time it's going to take, if you're even able to get it, is not worth it, because a lot of these goods are late. Some of them may be perishable. They're certainly time sensitive in terms of seasonal deliveries for the holidays. So the reality is, it's not going to be an easy situation trying to get goods off the pier at a reasonable rate.
Richard, you bring up a good point, and I think the reality is, too, getting any confirmation back to Hanjin as to what charges have been paid and what's been unpaid is going to be a time-consuming process at best.
Right. So
at the mercy of time.
Yeah, I mean, at this point, people just want their goods. Next slide, Rick.
While we change slides here, Matt, do we have any questions that have come in?
Yes, actually, Richard, if you could briefly explain the difference between a Chapter 11 and a Chapter 15 proceeding.
Yeah, sure. Chapter 11, as I said earlier, is a reorganization. A company, in the context of a U.S. company, it's in bad shape financially, but the company believes it has the ability, or if given the opportunity, to reorganize itself, improve how it manages things, and become viable again. But it needs the protection of the bankruptcy court to keep its creditors at bay. And then, in order to satisfy the creditors, they have to provide a plan of how they plan to reorganize and how, in time, and to what extent the creditors will somehow get some satisfaction of their claims. So it really is just a device to give a company a chance to take a breath, step back, without being hammered from every direction by the creditors, and become wholesome again. Chapter 15 is nothing to do with that. The Chapter 15 is merely a device by which a country such as the U.S. can cooperate with a foreign bankruptcy proceeding, so as to ensure that the assets, the bankrupt and its assets within its jurisdiction, in this case the U.S., are protected in order to allow the court in Korea to manage the bankruptcy. Is that clear?
Great. Yes, that is. And I have one additional question, if we can address it right now. Can a shipper become a beneficial party to these proceedings?
Probably, at least in one circumstance, it suggested itself to me, because not all goods, of course, are shipped, prepaid in terms of between the shipper and the receiver. I mean, if the goods were being shipped, with a freight, on an open account, they haven't been paid for. If they're in some way the shipper has yet to be paid for the goods, and he still has a security interest in them or an interest in the goods, I would guess that they have a right to take an interest in this as well.
Okay, great. I guess we can go on. There's some more questions, but I'll feed them in later on in the presentation.
Okay. All right, so on this panel, some of what I've already said kind of speaks to it. What's important, I think, from this is a number of things. And I imagine those of you who have been trying to follow this have picked this up in one way or another from the various trades. There is an ongoing effort to try and get the means to get the vessels into port, the ones that haven't been received yet, and the containers discharged. There were, at the time of the bankruptcy filing, 13 vessels in U.S. waters destined for U.S. ports. The terminals, as you know, wouldn't take them in. They wanted to know first who's going to pay for it, and they were also afraid that if they did take them in, they would have problems getting them out of the port because the people, the interests that had to provide the bunkers and other supplies to the vessel wouldn't necessarily want to deliver them without getting paid as well, and the vessels might get stuck sitting there tying up port space. So it's been a big priority, and probably the biggest issue, from the get-go, from the point of view of the beneficial cargo owners and the service agents, the forwarders, the NVOs, the customs brokers. What's going to happen to our freight? When are we going to get it? How can we get it? And there is no, there really is only one answer. Somebody's got to come up with the money that's going to allow these vessels to be berthed, offloaded, reprovisioned, and sent on their way. Now, the Korean government just recently, has announced that they're providing some of that funding, and the biggest, one of the biggest shareholders of Hanjin Korean Airlines is providing some of that funding. Figures that I heard, and don't go to don't go to court on these, is that it would take something in the neighborhood of $170 million to discharge all the vessels that are need to be unloaded. It doesn't sound like they've quite reached that figure, but there's a significant number of vessels in different locations, not just the U.S., that have actually been unloaded. Apparently, of the 97 or 94 vessels that Hanjin has, apparently 47 at least have already been unloaded, and they're maintaining that they think that the bulk of them will be finished by the end of October. In the U.S., I only know of 4 vessels that were allowed, for which money was provided to be unloaded, and I only know of 2 of those that have actually made port. Possibly the other 2 did. I have no idea at this point. Maybe somebody else has that information. What happened to the other 10? There's a lot of those vessels are leased vessels, by the way, and the Korean bankruptcy court ordered 35 or 40 of them back to Korea, with the understanding that they're going to be immediately given back to the lessors in order to stop the bleeding of leasing charges. So it's possible, some of those containers, some of those vessels were part of that. I just don't know. It's hard to keep track of some of these things. One interesting development, it's an issue that's going to have to be dealt with, and it spawns other issues, is the fact that Hanjin has taken the position that it's not going to be doing any on-forwarding of vessels, of goods, that once they're discharged, if they had received them on a through bill for inland delivery or for on-forwarding, they're going to drop them at the port when they can discharge them. It'll be up to the beneficial cargo owners or their agents, or those who have, are party to the contract of carriage, as NVOs often are, or forwarders as receiving agents, to make whatever arrangements they can and pay what fees they can. And as we mentioned, those could be exorbitant, to get the goods off the pier onto a inland carrier or a container transfer service, and get them delivered or on forwarded. The reality is it's going to be very hard. I think a lot of domestic carriers are not sure they want to get involved in this, because aside from the fact that they don't want to find themselves in a situation where they are not they're not making money, they're going to be stuck with empties very possibly, and there's a whole issue involving empties, which I'll mention. So the cost of getting goods off the vessel, out of the port, and delivered or unforwarded is likely to be significant. In some instances, it's apt to be redundant. On a prepaid shipment, for example, you will have already paid. Somebody will have already paid Hanjin for the delivery charges and the unforwarding charges. Hanjin says they're not going to refund that. So if you do get a container that was subject to that kind of shipment, you according to that exhibit attached to the order, you should be allowed to deduct what you already paid to Hanjin. But as a practical matter, I'm not sure how that's going to work out. But if you can't deduct, if you're somehow that you're frustrated in that effort because of lack of cooperation by the whoever is handling it at the court, I guess, then you're going to find yourself paying additional, or forwarding or delivery charges. It's and then the issue becomes, who's really responsible for that? Well, you could make a claim against Hanjin, and if you want to do that, then any kind of claim you might have, including that, would have to be done in Korea, in front of the Korean court. The U.S. court has indicated it's not at this point sure it has authority to even entertain claims, have them filed, or depending on who you're dealing with, you might be able to go to a court. But the real crunch here is that it's all going to fall back on the cargo interest, the beneficial cargo owners, and their attitude is going to be, hey, I paid my freight. Why do I have to pay all these extra charges? And they're going to be looking to the intermediaries who represented them and handled these shipments for them for some kind of redress, and that's another big issue. Rick? There was and still is to some extent an issue involving the empties, which I think I mentioned. There is, as I understand it, a negotiation going on between the leasing companies, Hanjin, to the extent they have their own containers, major shippers, people who have literally thousands of empties sitting around, trying to come up with an agreement, a protocol, which would provide for the orderly return of the containers. Hanjin has already announced that they're not going to be charging detention charges on goods on containers that are returned, but if they're returned in a reasonable amount of time, and if somebody holds on to them beyond the time they could have reasonably returned them, yes, they will get stung. But for the time being, they've waived that kind of a claim, and it looks like the intent of the negotiations involving return of containers is also to avoid having to put any additional charges on the people that are holding them, the terminals, the ports, the yards, of course the cargo interests, or any truckers that may have been stuck with them. But again, that hasn't been finalized. It's been going back and forth in terms of the drafting and redrafting, so we don't know at this point what that's going to cover. And I know for a fact from an information I was given, it doesn't cover the chassis, and yet you do need chassis, to bring goods back. So I'm not sure how that's going to play out either. But to the extent that anyone subject to the FMC's jurisdiction, and that would certainly include the terminal operators, is gouging, the FMC is definitely looking into examining this, and will probably be accepting complaints. Rick? All right, I've covered that. This last point is very important. It's a pretty short window within which the Korean court has set for setting for creditors and others to file claims. In a U.S. bankruptcy, as a rule, it's a much more extended period of time. And a lot of the things that people might have reason to claim against Hanjin may not even come up within that interval, because we're talking about October 25th is the drop-dead deadline. But if anybody thinks they have any claims, then they have to be very mindful of that deadline. So, getting down to some of the nitty-gritty as it affects the the intermediaries, a lot of the issues are going to affect the NVOs in a number of different ways. If the goods were shipped in terms of arriving goods, shipped under a NVO's house bill by an agent overseas, which we don't recommend it be done as a matter of regular practice. But if that's the case, then the NVO, as most of you understand, is the carrier for purposes of that shipment. They're the actual shipper and the actual consignees on the bill of lading, and that contract of carriage is between the NVO and those parties. And those parties, at least in theory, don't have any direct claim against Hanjin, and have the right, at least again in theory, to look to the NVO for performance of that contract. So if these goods have been held, if shipments subject to an NVO's inbound house bill have been held up and frustrated in their delivery, if they were perishable in some way or otherwise subject to loss of damage, then the NVO is going to be looked at by the beneficial cargo interest for some kind of satisfaction. And the NVO is going to have to fall back on their bill of lading contract terms on the back of the bill of lading, and their tariff rules, which of course they have to maintain electronically under regulations enforced by the FMC. A well-crafted bill of lading and hopefully the good terms and conditions, but tariff terms and conditions should have a force majeure clause, should have a liberties clause. Both of the force majeure clause, of course, allows the party invoking it to claim that anything that went wrong was not something they knew of, could have avoided, and therefore they're not they can't be held liable. I don't think anybody knew that Hanjin was going to file, except possibly very much at the last minute, when the days or maybe a couple of weeks prior to the filing. So that's a possible way of defending against that. The liberties clause gives the gives the NVOs a lot of latitude, as it would any carrier, to to stop movement of goods in transit, to deliver to another port, a number of other things, which I assume many of you know of. And again, that gives you some latitude. But the reality is that there's apt to be some very bad blood over this, especially with the shippers or the receivers that are less willing to be understanding and compromising. On the outbound side, the NVOs are going to find themselves possibly in a bad position, because if they had already booked a shipment with Hanjin before they filed, and they issued a house bill, well, at that point, of course, the shipment was theirs, and the filing doesn't exonerate them from being subject to the contract of carriage. And even if they didn't issue the house bill, once they are in possession, and I use that in air quotes, of the shipment, it would be, and it was destined for an export move, the bill of lading, the contract also attaches, even if it hasn't been issued yet. So you're going to find themselves in much the same position, where they're at that point, if they were able to pull the container and or redirect it, that was great. Although my understanding is that Hanjin was taking the position, if that was as the containers like that, they had to be devanned by the beneficial cargo interest, although in theory it would be one of their shipping agents, and we booked in another container because Hanjin, that its containers are the ones it leases. That's part of the bankrupt estate, and it can't be used for other purposes at that point. So that creates some problems. So if anybody's got goods that have been sitting on the pier that were destined for export, and they've issued a house bill, then they've got some issues. The other problem is, in either case, if the goods are being shipped on a prepaid basis, the NVO on a Hanjin bill of lading is the shipper. They're responsible for the freight charges and anything else that might be assessed. So if the NVOs on an inbound shipment is the consignee, well, under the terms and conditions, the merchant is deemed to be both the shipper and the receiver, among other parties, and the NVO is going to be on the hook for claims of any freight charges or other charges that would otherwise ordinarily be due. The same may be true on the outbound, because the carrier can, in some instances, claim that once you book the shipment and the container was in hand, at least they've earned the freight charges regardless whether or not the move actually took place. So I don't see the NVOs being in an enviable position. I think you're going to be getting it from both the shippers and from the from the carrier's point of view. Forwarders are a little better off because they are just the travel agent for the shipments. They're not the actual carrier, or they're not acting as a shipper on behalf of the carrier on the master bill. And but they frequently, when they book, they have contracts, as does the NVOs, with the carriers, and frequently when they book shipping direct under a carrier's bill, with the actual shipper and the actual consignee are listed, the carrier is accepting it on the strength of the forwarder's credit with them. Therefore, if the shipment doesn't get paid for it, they can look to both the NVO or the forwarder for that. The other problem is, if you have rate agreements with these carriers as an NVO or a forwarder, they require a certain volume of goods be shipped in consideration of the more favorable box rates. Obviously, because of the intervening event of the bankruptcy, many of these contracts will go unfulfilled. Seems illogical and unlikely that the that Hanjin or its trustee would turn around and say, well, you didn't complete your contract, so we're going to re-rate all of the bills of lading that you had already booked with us, and we're going to look into you for the for the additional charges because you didn't fulfill the contract. I don't think that could happen, would happen, but stranger things have happened. And insofar as your relationships with the any service agreements you have with your shippers, those terms and conditions are going to override, both in terms of the freight forward or the NVO. In most cases, I mean, it depends on the contract, but most cases it's going to override the bill of lading terms. It's going to override the tariff terms in the case of the NVOs, and you may find yourself without the defenses that the bill of lading or the tariff rules might otherwise provide. This leads me to the point where I can say I can't tell you with any confidence or assurance just how much you can predict how this is going to play out for you, but I can say that it's a really novel situation. The last major container bankruptcy was U.S. Lines in 1989, and while there are any number of people in the shipping industry and the bar that works with them that were around in those days, that experience was different, and I'm not sure how much we can cull from it to guide us in this case. This seems like a whole new set of issues that are, that very few people have any immediate answers for. Rick?
Richard, you bring up some good points. I think obviously the master service agreements, the shipper contracts, are certainly something to pay attention to, but we've also seen that some of the force majeure clauses within the NVO conditions of carriage vary slightly. So I guess I'd restate your comment that if you haven't already, just to make sure that you have in fact looked at your carriage terms and make sure that your force majeure clause is fully understood.
Yeah, it's unfortunate the force majeure clause is not that standardized. You can read one or two or three or five, and they will sound very much similar, but sometimes there are differences which can make it difficult to give it the effect you want. And there are people that don't have them, which is unwise.
We've seen that. Matt, do we have any questions that we can insert here?
Sure, we've got a couple here. One of them that came in is, would it be prudent, question just rolled off my screen, hold on. Would it be prudent for someone to file their claim now? I'm not certain exactly what the claim is for, maybe for, against maybe an insurance policy or with the bankruptcy court.
I guess I could answer.
That would help because Rick, I can't answer for Rick.
As far as an insurance claim, it depends on I guess the type of claim, but if it's certainly for the cargo itself, if there is goods that are on a Hanjin bill of lading or on a sharing agreement stuck on a Hanjin vessel or somehow stuck at port, I would say you should put those cargoes on a claims watch basis with the insurer, and obviously things are yet to really happen, but putting the carrier on notice is certainly a wise idea. Keeping track of the additional charges that might be incurred and releasing freight and things like that may or may not be recoverable under a cargo insurance policy, but I would certainly keep track of all those costs and make sure that you do have a dialogue with your insurer.
And insofar as filing a claim with the bankruptcy court in Korea, given the short window within which, given the short window which has been provided for filing those claims, I think you can't help but do that. To file a claim now. In the U.S., when you file a claim, it has to have some supporting information which will give some credibility to it. If not, you, as a customary practice, the trustee or the receiver of the bankruptcy estate would certainly reach out and say, well, what do you have to prove that this is a valid claim? My understanding is that the Korean the bankruptcy law, while similar in general terms to ours, is a little different, and it's hard to say if they'll accept a claim without support, but better safe than sorry. I mean, it's that simple.
Okay, and one other question. For any vessel that is still arrested or seized or somehow in control by another party, what will happen to the cargo that's on that vessel?
Interesting question. I think I try to make. I'm getting some feedback, Matt. Is there?
Richard, change to your handset. If you could just take yourself off speaker.
Okay. Let's hope I don't lose anybody. You still there?
Yes.
Yes.
Okay. It's a good question. I think I mentioned earlier on that in the order, the preliminary order issued by the Chapter 15 court here in New Jersey, it reserved ruling in some fashion on what to do with that vessel and the goods that are on it, and it's yet to take any step in that direction. For the moment, basically, unless Hanjin, is in some fashion willing to come to terms with the people that arrested it, and the court here says, fine, we're willing to endorse that, the vessel and the goods are going to stay frozen at the moment. It's
Okay.
I think the vessel was called the Montevideo.
Hey, Matt, do we have any other questions that we could put in here, or just move on?
Go ahead and move on. There's a couple more, but I'll bring them up later.
Okay.
Rick, why don't you sort of get into what you wanted to discuss at this point? I don't want to. I've been hogging too much of the time.
Okay. Let's skip over here. So, I think there's a couple steps that might be self-explanatory and that have already been done, but it's worth mentioning. So, obviously, it's important to assess what, in fact, is on Hanjin vessels, what's been detained, and notify all clients in writing. It's one thing to have the discussion, but make sure that you are, in fact, getting all of this in writing. And it may be an opportunity at this point to, whether you're an NVO or a forwarder or even acting in the capacity as the customs broker on some of these entries, to restate your terms and conditions. I think we have to hope for the best and expect the worst in terms of how certain clients might react to the situation, and we need to take the opportunity to restate our position as intermediaries here so that they don't have any false hopes that the NVO or the forwarder is somehow going to be picking up the additional costs that might be incurred here. Advising the cargo insurance provider, obviously we've mentioned that there may be situations in which the cargo insurer is going to reimburse for some of these costs. There's a couple clauses, sue and labor clause, the forwarding clause, that more or less states that the insurance company will reimburse the insured for any costs that they incur to protect freight. So there's going to be kind of a fine line as to what is considered protecting freight versus simply paying for on-forwarding charges. And really, these are going to have to be dealt with on a case-by-case basis. There's some situations that are already coming up that are very difficult. One quick example, I have a client that had forwarded on $100,000+ of monkfish destined for Korea, cargo sitting in China. It cannot be on-forwarded to Korea for obvious reasons, but at the same time it can't be offloaded in China because it doesn't have the correct paperwork to do so. So each situation, I think, is going to need to be discussed with the client, with the insurance provider, if in fact cargo insurance is provided, and certainly legal counsel. And if you, just as a reminder, if you don't have legal counsel that's infinitely familiar with maritime law, I would suggest making sure that you have found one. Certainly, Richard Furman is one option, and we could potentially get you the information for others if geographical restrictions make that difficult. But for the U.S., Richard can certainly help out. Another point, remind shippers of the carrier's terms and conditions as well, and the bill of lading, which is essentially binding them to this shipment. it's really something that I think it might be a lot of time spent on the individual clients, but the more you're making them aware of the situation, hopefully the more comfortable they'll be in understanding that you're not the responsible party here. I think when you look at the overall exposure to a transportation intermediary, probably the largest exposure here is going to be that of your receivables. There's going to be additional costs accrued, obviously, in on-forwarding cargo, storage charges, things like that. Make sure that the clients are fully aware of the additional charges and that they are their charges to pay. So make sure you do get their confirmation in writing as to the agreement of payment of those charges. And I'd pay particular attention to cargo that's either not insured at all or low-value cargo. Recycled cardboard, granite, things like that. Those cargoes may represent the biggest risk to you in that the costs to on-forward may exceed the cost of the goods, and it could be an abandonment situation. So make sure that there's particular attention paid to the values of some of these cargoes as well. We covered most of this. Beware of your obligations to import freight. In a second, Matt Zahner is going to touch on some of the issues affecting some of the vessel diversions and ISF requirements and some of the issues that are going to come out of that. I did want to just take a chance to talk about some frequently asked questions that we've been getting. First one, what if my client refuses to pay me for freight charges? Well, I think that's a very real scenario, and depending on your terms and conditions, you may have the ability to hold freight for payment. Remember that might be your last opportunity to insert any kind of leverage into this situation. We covered this a little bit. Will the cargo policy pay for extra freight charges incurred? It likely will, but again, we really need to analyze each claim on a case-by-case basis, and as most of you know, no cargo policy is the same as the next, so there may be some minor differences in between policies. So, and touching on the abandonment issue again, if you have a client that's threatening to just walk away from their cargo rather, it's important to make sure that they understand that they can't do this, and that's likely going to put you in a position where the carriers are going to be coming after you as the forwarder or the NVO for those charges. So that's something to be very careful of. Unfortunately, there's limitations in a cargo insurance policy as far as what it will cover. Its design is to cover physical loss or damage to the cargo, and a few other things around that. But clearly, with the time that we have, especially on the imports, we have goods that are going to be potentially going into Christmas and holiday market. Unfortunately, loss of market, pure delay is not insurable. Now, most shippers understand that, but I think there's a few that don't. And certainly that's a situation you're going to have to work on a case-by-case basis. But by all means, please contact your Roanoke trade representative to assist with those cases because we might be able to offer some advice there. We've heard rumors that Hanjin's requiring a discharge fee or a bond amount, and early on that amount was thrown around as $1,500 to $3,000. So far, these are just rumors. I would say that if there are legitimate costs that are being put out there as far as release fees and things like that, make sure they're in fact just that they are legitimate, that it's in writing, that you perhaps reviewed it with your counsel before paying those charges, and again before getting your shippers to agree to pay for those charges as well.
Rick, can I add something on that?
Sure. Yeah.
I think this particular issue came up more in terms of the marine terminal operators than Hanjin, because the court in the preliminary or the interim order made it clear that Hanjin can and should discharge the cargo, but they he used language along the lines of at the usual and reasonable rates that would otherwise be charged. And I think if Hanjin were to try gouging on that under those circumstances, I think the court would would take a dim view of it. So I think it's the MTOs that are really the source of that rumor. And in fact, some of my colleagues have indicated that some of their clients have actually encountered discharge fees of up to $3,000.
Okay, thank you. Another question that's come up is, well, for the folks that do have credit insurance, is credit insurance going to cover my shipper's non-payment for these additional charges? And most likely not, unfortunately, because there's going to be a dispute behind it, and credit insurance really does not respond to non-payment due to disputes. So again, potentially the best leverage that you have is to get paid in advance of releasing freight and making sure that the clients are all agreeing in writing as to acceptance of the additional charges. Those are probably the best options that you have here. Another question that had come up early on is, well, what about my NVO or my freight forwarder bond, my OTI bond? Won't that help me out? And short answer there is no, it's not going to help you. Really, the bond is there to protect the carrier from non-payment of freight charges. And to that point, I would say don't let the situation get to a point where the carrier is coming after the bond. That's going to be a position where very little leverage in getting out of, so prevent that from happening at all costs. Okay, and what about errors and omissions insurance? We've talked about cargo loss and physical loss, but for those shippers that may still want to assign blame to the intermediary, clearly your errors and omissions policy is going to provide defense of that blame, but really you're not the liable party. So as far as the errors and omissions policy paying out any type of damages, that's probably going to be very rare. I'm not saying it's going to be, it's not going to happen, but between your conditions of carriage, terms and conditions, and the fact that you're acting as an intermediary, there's going to be very little responsibility on your part that the shipper can assign to this incident. Again, if situations do come up, get in touch with your insurance provider as soon as you can, discuss the strategy, and if needed, the errors and omissions policy should be there to defend you.
Rick, can I ask a question? I'm sorry, go ahead.
You want to add anything on that?
No, I want to ask sort of supplement that question. What if the claim is made that, and this would go to some of the relating clauses that might be invoked, that the intermediaries should be liable because of negligent selection.
Mm-hmm. Yeah, that's a point. Yeah, so I think we've heard that. Some shippers are saying, well, you're the one that picked Hanjin, and you should have known about this. And I think that's you can obviously assert that, but if you look at who the competitors to Hanjin are out there and their financial condition, there's a considerable amount that are in similar tough financial times. So to try and say that it's your fault because you put cargo on board this potentially insolvent carrier, I think that's a bit of a stretch in the overly competitive environment that we're in. It could potentially be a claim. I think that's something that would have to be looked at on a case-by-case basis. I think an answer to that, potentially moving ahead, how do we prevent these kind of things? I've said this in other discussions, is maybe where the opportunity can present itself, give your customer options. So it may be Hanjin is the cheapest carrier on a certain trade lane. If potentially there is an alternative, maybe give a menu of options. I understand that's easier said than done in a lot of situations, but I would kind of suggest that maybe that's kind of an option to put the shipper in the opportunity where they're making the choice, and you're not necessarily directing them to a sole option here. Did I answer your question, Richard?
Yeah, I was also curious as to what extent the policies, the various policies might entertain that claim.
Yeah, it's probably errors and omissions and not bill of lading legal liability for a situation like that. So I did want to take a second to bring Matt in on the topic of bonds and some questions that have already come up with Roanoke about how to handle ISF on some of these vessel diversions. A particular question that came up to me the other day was on a voyage destined for Canada, vessel diverging into U.S., and how to handle the ISF charges.
Sure, thanks, Rick. Beyond just moving the boxes, a lot of countries have advanced manifest filing requirements, advanced information filing requirements. And in one of these situations, a Hanjin vessel was originally destined for Canada to offload containers, and at least the containers we were working with were that ship was diverted to a U.S. port, and then those containers would move in bond directly to Canada. So the arrival in the U.S. port triggers an obligation to file ISS, but clearly the vessel has already sailed, so it's already in an untimely situation that by itself has violated the ISF regulations. Customs has addressed this. They put out a document that addresses scenarios. This scenario wasn't specifically addressed in there, but it was touched on a few years earlier when the Vancouver port strike was going on. But essentially, containers won't either be allowed to be offloaded or won't move off the pier and out of the container yard until an ISF has been filed. Customs wants that information to target off of, or it's going to be a very heavily inspected container with a lot of those accessoral charges applied to that devanning and inspection and things like that. So who has to file the ISF? It all depends on where that container goes. If it's going to be an in-transit move to an inland port or it's going to enter the U.S. commerce, the ISF 10 has to be filed, and the party, the regulations spell out who the party is that has to file that. If it's an in-bond move, like a T&E or an IE, the party that files that in-bond document with Customs has the legal responsibility to file the ISF. By strictly interpreting the ISF rules, it's late and it's subject to liquidated damages. However, I believe Customs will be fairly understanding and lenient in acknowledging that this, timeliness issue really wasn't anyone's fault. As long as you can show you took best efforts to file it as soon as you knew you had the obligation to file. So, the thing is, those containers need to have an ISF filed, or Customs will really put the halt on its further movement. The issue of bonds, like Rick mentioned, the OTI bond, that's really to protect the steamship line to get paid by the party who's shipping, or it's also protect the shipper from having to pay twice if the intermediary never paid the carrier. There will likely be people making claims against the bonds, and the sureties will be working with the OTIs to work through those and to see whether or not the claims really fall within the scope of the bond, if there's been double payments and things like that. And one comment that did come in, we have some questions that we won't be able to get to, and by all means we're going to compile answers to the questions we've received and make them a Q&A document that will be with the recording of this entire webinar presentation that's available on the internet within a couple days or so after this presentation. On goods that are likely to be abandoned, Rick talked about the low value shipments. There's no commercial value left on them, and it's not worth it to move it further on from wherever it got offloaded at. By all means, as the forwarder or the NVO involved with those containers, work as best as you can with the terminal line, the stevedore, the steamship line, whoever's involved with that, to have that addressed as soon as possible, because if that container's just sitting there, someone somewhere along the line will eventually apply demurrage to it. Hanjin has talked about not applying demurrage or late charges on containers that are not returned timely, but they're not the only person in this mix, and containers taking up space start racking up charges very quickly.
Yeah, that's a good point, Matt. say, you know, the carrier has as much obligation to ensure that that's done, but given the situation, there may be people missing from desks and things like that at Hanjin. So I would say it may be an additional task that the folder or the NVO has to manage, but for cargo that may be destined for abandonment, you know, make sure that the GO proceedings and any kind of salvage proceedings do occur on a timely basis, because that might be the best way to save that type of situation.
Yeah, I mean, sticking your head in the sand and hoping it goes away isn't going to work. Right? We've seen this outside of the Hanjin situation. We've seen some of these where containers sit for months and months, and six-figure demurrage bills come in as claims against the NVO.
Yeah, that's a good point.
Okay, we've got a couple of questions. If I can toss these out to you. And just a general caveat, this webinar is not intended to be legal advice. We'll give you some guidance. You really should, you know, work, if you have a legal question, you really should work with a knowledgeable transportation attorney. There's loads of them out there. If their primary focus is on environmental law or work comp law, you might want to move down the list a little and focus on someone with transportation as a background, as a major emphasis in the work that they do. But you know, one question came in: who's responsible for, and I'll call it slot chartered containers? Let's say you have a bill of lading from Zim or Evergreen or whomever, but it was loaded on a Hanjin vessel. Who's responsible when that container is offloaded at the nearest seaport and it stops there?
Is that mine or yours, Rick? I guess it's me.
Why don't you start, and I'll jump in.
Okay. You know, the problem, of course, is that the the containers are not necessarily easily accessible. They could be loaded in a fashion that they couldn't get them off even if the vessel even if the vessel is at port. The reality is, it's the person who issues the bill of lading who's responsible for that, those slot chartered containers. The recourse they have, of course, is back against Hanjin, possibly others. But the bottom line is, whoever issued that contract of carriage, even though they're as much a victim of this as anyone else, they're going to be responsible. They're going to be much the same position as I described that NVO would be in. They're going to have to find ways to either deflect claims or, otherwise come to terms with their be beneficial cargo owners. So it's that simple. I mean, it's whoever issued that document, that bill of lading.
Okay, and Richard, just this question, you may have touched on it already, but if someone does have a claim against Hanjin, do they present it in the New Jersey court, or do they have to go to Korea in that bankruptcy court?
Yeah, no, the New Jersey court at the moment says it's not going to entertain those claims. Doesn't even think it has authority to do it. They'd have to go to Korea. If anybody's interested, I can give you the name of a major firm over there. By major, I don't mean necessarily expensive, but somebody that's a firm that's very much involved in this. It's representing a lot of cargo interests in the situation. And my understanding in my communications with them is that it doesn't have to be too expensive a process, but obviously there'll be some fees and some expense. But yes, you have to go to Korea.
Okay, and then a quick question for Rick. We're hitting up on that 2 o'clock deadline. It's not really a deadline, but we don't want to stretch everyone's day out. This presentation recording will be available. The slides will be available. The Q&A will be put together, and we'll email links to everyone who registered. Rick, is there any type of insurance that could have worked best for an importer or a shipper to protect it from the Hanjin situation?
Well, really, certainly no more than currently exists. So, the all-risk insurance is likely to help with some of these charges. Unfortunately, the sue and labor clause may be covering some of the on-forwarding charges, things like that. It's really limited to that. So the loss of market component, the lost business, or what we typically see is the significant discounts between importer and buyer's contracted terms, those are not recoverable under any type of insurance, unfortunately. Even for a Fortune 500 company, there exists no coverage for this type of thing. So again, I think I go back to a comment I made before. Maybe the lesson learned here is to use this situation as one that shippers should be cognizant of happening again in the future. We're already hearing that there's some other lines that are in potentially similar financial condition, that maybe shipping times are moved forward to get cargo in to the states earlier to meet certain deadlines. Look at other transportation options that might be quicker service times, or even going to different modes of transportation for time-critical goods. It doesn't sound like a solution as much as an excuse, but it's really that's really the only other option. Unfortunately, there's no other insurance here to protect the shipper from those loss of market issues.
Okay, great. Thanks, Rick, and thank you, Richard. With that, I do want to thank you for a very informative presentation. We did get a lot of questions that came in. They were fairly specific, so I didn't want to read them out there and start maybe misguiding people who might think something like that applies to them. But we will look over those questions and provide answers as best we can on them. Again, I want to remind you today's recording and the slides will be available on our website link, and we will also have the Q&A document there. Now is a good time to enter your questions using the question pane if you still want them to be captured on the right-hand side of your webinar viewer. Also, if you want to find out some updates on the Hanjin Bankruptcy, RoanokeTrade.com website, we have a tab that runs across the top. One of those items says Info Spot, and under that Info Spot tab, we have the Hanjin issue as an emerging matters section. Again, thank you for joining us today, and this concludes our webinar.